Okay, so let's get started. Good morning. Thank you for joining us. My name is Chris Fundora. I'll be our moderator as well as one of our panelists for today's discussion. The objective this morning is to provide you with directly applicable information and strategies on reopening your business, retirement plan flexibility, and providing guidance on PPP loan forgiveness. We will absolutely have time for Q&A, and we're going to facilitate this through the chat feature. So as you have questions, as they come up, please message Traphagen CPAs and Wealth Advisors directly. We'll gather all questions throughout and facilitate a conversation at the end. This morning, I'm joined by two very intelligent men, and who have an incredible amount of knowledge that they want to share in their respective specialties. Michael Morea is the founder and managing member of Morea Law. Mike has over 20 years of experience providing counsel on matters of employment law. He's worked with many clients from small business owners to Fortune 500 companies. While Mike focuses on assisting clients with compliance in order to avoid litigation, he also has extensive experience litigating employment and other matters in both state and federal courts. He is passionate about providing employment law counseling to owners of small and medium-sized business, as they're typically underserved in the legal field. Mike has received numerous awards and honors for his work, most recently being named to the Thomson Reuters list of New Jersey super lawyers, which is an honor reserved for only 5% of attorneys in New Jersey. So Mike, thank you for joining us.
Thank you for having me.
We'll also be hearing from Darren Thomas of Traphagen CPAs and Wealth Advisor team. Darren is a senior tax manager at the firm. He's a certified public accountant, a licensed attorney in New York and New Jersey, as well as an IRS enrolled agent who is federally authorized as a tax practitioner. As a member of the AICPA and New Jersey Society of CPAs, Darren currently serves as the leader of the State Tax Interest Group. Darren has extensive experience with corporate tax planning, and we'll be discussing features of the Paycheck Protection Program today. As for myself, I've had the privilege of partnering with many of you on personal and corporate retirement planning. So briefly, I'm a certified financial planner and chartered retirement plan specialist, providing fiduciary counsel and guidance. I'm also a member of our Traphagen Investment Committee, where we collaborate on development and execution of our portfolio investment strategies. I'm passionate about financial planning and education. I provided insight to publications such as Financial Advisor Magazine and Yahoo Finance, and have led many seminars and events such as this on investment and tax planning. I continue to teach financial education courses at Bergen Community College, and I've been selected by the Dave Ramsey organization to provide financial guidance to listeners. I'm going to discuss strategies on maintaining flexibility in your retirement plan while looking for avenues to mitigate tax obligations. So again, please feel free to submit questions throughout this time to Traphagen CPAs and Wealth Advisors in the chat section. So Mike, please feel free to take it away.
All right, thank you, Chris. So I wanted to thank everybody for joining us this morning. I thank Darren and Chris for inviting me. As Chris mentioned, I'm going to be talking about the issues that business owners need to think about as you reopen, or maybe you reopened and you didn't think about these issues, and you got to think about them now to make sure you've addressed them. As a lawyer, I guess I have to give the disclaimer: this is not specific legal advice to anyone's business. The guidelines and the things I'm going to talk about are very high level. I really more so as business owners, you can understand these are the issues I need to think about. These are the things I need to consider and decide whether it's appropriate for my business. So the goal obviously is to reopen your business so it can be successful, avoid any missteps which could cause you liabilities, and provide a safe place for your employees and your clients or customers to come to work. Reopening is in a very different environment than it was when things started shutting down. And a lot of businesses now have to think about things they've never thought before. For example, most retail stores, most office businesses have not really had to think about a lot of safety issues, not like a manufacturing company or a plant or something like that. And now you do. I mean, you don't have the same issues. You're maybe not dealing with heavy machinery, but you have to deal with the safety of your workforce. You have to think about laws you haven't ever considered before, such as the OSHA Act, which requires you to provide a safe workplace. Generally, offices are safe, and you really don't need to do too much more. Now you do. It's really going to be 4 steps to go through to help open your business properly. First is going to be you have to develop a plan for reopening, complying with all of the applicable and new safety laws and guidance that's out there. You need to determine who's going to come back and do that in a manner that doesn't violate anti-discrimination laws. And doing that may not be as obvious as you think, and I'll talk about that. You need to be prepared as to what you're going to do if an employee gets COVID-19. Maybe you'll be lucky, nobody will. Maybe you won't, but you need to be prepared for it before. And you need to make sure that you have your leave policies and your workplace posters up to date, because there have been a lot of changes to those. There are a lot that apply to potential issues if an employee gets sick with COVID-19. And I'm not going to go into detail on those, but I just want you to be aware of what those laws are, so you know if they apply to your workplace and you can make sure you comply with them. So the next step is going to be to develop your back to business. The first step is develop your back to business plan. So, first question is, can I reopen? Should I reopen? Can I legally and am I able to comply with what I need to comply with to reopen? Determine you're going to reopen fully or in stages. Some businesses, and a lot of businesses like restaurants, it's been incremental and they've had the decision made for them. They could open for curbside pickup. They could open for outside dining. They can open for inside dining. New York, some places, I don't think New Jersey, I don't think we've quite gotten there yet. I don't know if we have a date for that. But if the law isn't required, as a business owner, you're going to have to decide what's appropriate. Now, you need to develop who your response team is going to be, who's in charge of these COVID-19 issues. For a small business, it may just be the owner. It may be 1 or 2 people. If you have a large organization, and this is what in the slides, you're going to have senior management, your legal department, your finance department, facilities, HR, your supervisors and managers, all on board. I had a client who is a large company. They have a facilities department, they have an HR department, and they were both separately creating their plan. They finally got together and realized, but they didn't have the level of coordination that would have made it a little smoother and saved them a lot of time in the long run if they did it. So on the next slide, after you determine who's going to be your internal team, you need to coordinate with your outside people. You need to coordinate with your contractors. Simplest example is your cleaning service, because you're probably going to need them in there more frequently than you did before. You should check with your insurance agent to see if you have coverage for COVID-19 issues. I do know some insurance companies, at least the ones I've heard of, are specifically excluding claims involving COVID-19 from their policy renewals. But you should check, see what coverage you have so you understand. You should consult with your lawyer as far as what can I do, what should I do, what am I required to do. Check with your accountant. Is there anything you should be doing financially or planning to prepare for reopening or just the shutdown you've had? You need to understand what your landlord and building manager, if you're in an office, they may have an entry protocol that you're going to need to be aware of and comply with. And you need to make sure your vendors and suppliers are there. If your vendors and whoever supplies your key products or things that are crucial to your business are not open, then you're not going to be able to reopen. So after you get your team together, you got to determine what your workplace controls are going to be. There's a number of factors to consider. The primary one, at least from my perspective as a lawyer, the legal requirements and guidelines. And unfortunately for businesses, they're coming from all over the place. They're coming from executive orders. They're coming from federal and state laws. I mentioned the federal duty clause of the OSHA Act. They're coming from OSHA. They're coming from the CDC. The White House has issued guidance, and different industries are issuing guidance. A lot of places. One of the good things is, for the most part, most of those guidance is going back to the CDC and what the CDC recommends. So you need to understand what legally you can do, what you're required to do. And you also have to consider the nature of your business, because a hair salon is going to have very different opening requirements than an accounting or a law firm, or a food services firm, or a healthcare facility. You also have to take into consideration the size of your workforce. Smaller workforce probably make it a lot easier to deal with, but the problem there is a lot of small businesses do things a lot more informally, and you can't handle these issues informally. You're going to have to do them the way a large company would be, with creating documents and stuff like that, which I'll talk about. And you also have to consider your physical workspace and how it may need to be readjusted or not. So in all the guidance, there are a lot of common things. One of the things everybody's encouraging is teleworking when possible. Now, for some businesses, that's very possible. I'm personally in my office right now, but I'm a solo practitioner, so it's easy for me. But I could just as easily be from home. Retail store, that's not going to work as much for most positions. Restructuring the office space is something that is being not required, but it's required that business owners consider it. You're going to need to move workstations 6 feet apart, removing chairs from conference rooms so people are not sitting within 6 feet of each other. We've all seen the 6 feet of the space marked at the checkout lines at the grocery store or the big box stores. One thing I'm seeing a lot of is whether you should create one-way traffic around your office. People can only walk in one direction. Now that you got to consider it, but depending on the nature of your office, that may not be appropriate, because you may then have people walking through areas that they wouldn't otherwise be, or shouldn't be, or have no need to be, and potentially spreading germs. Plexiglass partitions when you can't have the physical spacing. And one of the things that's big, New York is actually requiring it, is limiting the number of people permitted in the store workplace. New York in phase 2 is 50% of MACA occupancy, and restricting non-essential visitors. So for an office environment, that's a lot easier because you don't need family, friends, and people in there generally. So you also need to consider, on the next slide, closing common areas. So the lunchroom, probably should be closed. Maybe have it open for limited reasons. If people are bringing their lunch and need a refrigerator to put things in, but otherwise it needs to be closed. Should limit in-person meetings. A lot of businesses, if they have larger workforces, are staggering shift times. So instead of having 2 shifts, they may have 3. Extend the overall workday, but they're having less people in the facility at the same time. Some stagger shift time. So during for the first shift, people are showing up half hour apart, so less people are physically coming into the business at the same time. Need to require it. Everything I've seen essentially requires this. When you have to require face coverings and potentially gloves in common areas and near others. Employers have to provide those face coverings to their employees. That's at least New Jersey and New York. You have to provide them. Have to provide hand sanitizer and antivirus cleaning supplies. New Jersey is also requiring that you provide your employees with frequent break times for hand washing. Doesn't really say what frequent is, but you need to consider what's appropriate. How often are they touching things? This one should be pretty self-evident, but you do still get people who think, well, I'm going to tough it out. I'm going to go into work. I'm going to show I'm committed. If they have any COVID-19 symptoms, they stay home. And to the extent possible, you should prohibit the sharing of equipment, phones, desks, computers. You shouldn't have, hot desking was very popular. Right now it's not, unless it's done with cleaning in between the different people using up the hot desk. On the next slide, if you do have any shared equipment, like you have the big printer, like a lot of law firms do have the big printer in the center office, you got to require employees to wipe it down. It should be required to wipe down before or after, and after they use it. Business travel, you need to assess, is that really necessary? Do we really need people getting on planes or driving to go places? As I mentioned, you're going to need to go with your cleaning company, because if you have any high traffic areas, if you do keep any of the common areas open, or you have any shared equipment, you're going to need the cleaning company in there more often to clean it, make sure it's safe, prevent the spread of this virus. Now, health screening is a big thing a lot of people are talking about. Most guidelines recommend it. New York requires it for businesses, that you have to screen your employees and essential visitors. New York does not require customers to be screened, but employees and essential visitors must be screened for whether they have the symptoms of COVID-19. Could involve, does not require to a temperature check. Temperature checks may or may not reveal it. You get mixed information on the usefulness of that, but a lot of businesses are requiring temperature checks before they would come in. Now, when you do all this, you need to document it. New York requires that you have a written safety plan and that you publish it. New York has 12 pages of guidelines for office businesses as to what those factors need to be, what you need to consider. So just saying, all right, I thought about it, I did it, not going to help you if someone gets sick and you get sued. You don't want to be at a deposition 2 years ago saying, well, yes, no, I'm telling you now, I thought about it. I have no documents that show you that I did this, but this is what I thought about. This is what I considered. You want to have the documents that show this is what we considered. This is what we did. This is why it's consistent with what the CDC is recommending. And this is why it was safe. Protects you. It also helps ensure that you, your employees, your customers or clients comply with it. So it helps make the policy actually enforced or used. Do want to make a note on health screenings. Normally, if you can't ask your employees about health issues unless it's job related. So you normally couldn't ask your employees, do you have a fever? Do you have a cold? Do you have a cough? Right now, the EEOC and the government has said that being COVID-19 symptom-free is job-related. That will change. So you can take temperature checks. You can ask about COVID-19 symptoms. You could require employees to be tested to see if they have COVID-19. You cannot require them to be tested to see if they have COVID-19 antibodies, which I guess makes sense. If someone's sick and has COVID-19 symptoms and could spread the virus, that's job-related. If they had it and they no longer do, that's not job-related anymore. You have to be very careful. You can only ask about COVID-19 symptoms. Asking about anything else, you're violating anti-discrimination laws. And potential problem for business owners is those symptoms have changed. When it first came out, there were 3. There's now, I think, 6 or 8 potential symptoms, and they may change. So this is not a create the plan, create the protocol, set it and forget it type thing. You need to make sure that it changes or is modified as the CDC guidance changes. Also, since these questionnaires and tests about temperatures, health symptoms, those are medical exams. That's medical information. That needs to be maintained confidentially. You can't throw that in your employee file or keep it in one stack. That needs to be kept separately. It needs to have limited access to only people who really need it. Otherwise, you're going to be running afoul of anti-discrimination laws and potentially the ADA. So now that you have all that in place, and that's probably most of the work, yeah, I said, who's coming back? And this will probably in large part depend on whether you're doing a full reopening or a partial reopening. You're bringing all your employees or you're bringing some of your employees. And you have to avoid the anti-discrimination laws. And one way that businesses can do it is if they're trying to protect their employees. You cannot decide that Joe is 70 years old. He's at higher risk according to the CDC. We're not going to bring him back because we don't want to put him at risk. Even if you have the best of intentions, that's illegal. That's discrimination. You will get sued for it, and you will be found liable if that was your decision. It's unexcusable. Or that, Sue is pregnant. Don't want to put her at risk. You can't make the decision. So you need to make them based upon things that you could demonstrate are non-discriminatory. Tenure, documented job performance. A lot of businesses are not good about documenting job performance. Everybody seems to get good reviews because no one wants to have a bad one. Wants to have a difficult conversation, or documented skills and experience. So as long as you can show that these are the reasons, have nothing to do with age, race, pregnancy, national origin, medical condition, or any other protected category, you should be in the clear as far as making the decision. So now I said you can't make the decision for your employees, but you do need to be aware that high-risk individuals will likely be entitled to accommodations if they request it. So it's up to them. It's up to the older worker, the employee with another underlying medical condition to say, hey, I'm afraid of coming back because I don't want to get sick, and I'm at higher risk of having a mortality or really serious complications of this. So under discrimination laws, accommodation laws, disability laws, you would have to accommodate them. Now, that may involve allowing them to telework, changing their work environment, restructuring, or just giving them time off from work until this passes. So, you gotta, like I said, you can't put it up, you can't make the decision for them, but if they request it, you do have to consider it. One thing that is a little different in the current environment, generally a reasonable accommodation, you don't consider the current economic conditions of a business. So if a business is going through a rough patch through a particular time, that wouldn't factor in. Right now, the EEOC has said we do consider that. This is so unique and so extreme that we do consider that, whether that's reasonable or not. Now, for a lot, employees aren't going to come back because they want to keep taking their unemployment, and there's extra $600. So, or they're afraid of COVID-19. Now, excluding the high-risk individuals, being afraid of COVID-19 is not a reason to come. For an employee to refuse to work, it does not entitle them to a reasonable accommodation. Similarly, an employee who lives with someone who's a high-risk individual does not entitle them to a reasonable accommodation. And if an employee refuses to come back to work and you offer them to come back, that will disqualify from unemployment benefits. And for PPP loan forgiveness, and this is really all I'm talking about on the PPP loan, at least the last guidance I'd seen requires that the business document the offer in writing and the rejection of the offer. And I believe is required to notify the unemployment division within 30 days, if that's the case,
Okay.
in order to it not affect their loan forgiveness.
That's right.
So now, handling an employee who gets sick, obviously should not return to work. Anybody who develops symptoms while they're at work, they should leave immediately. So now if you do have an employee who tests positive for COVID-19, the guidance is pretty clear. They have to stay home until either 14 days after being symptom-free, or they're cleared by a doctor to return to work. You do need to notify other employees and other people that the employee was in contact with of the possible exposure to COVID-19. You cannot identify the employee. I had this situation when it was first coming up. I said, but everybody knows who it is. It's the one guy who was coughing and is no longer here. Still can't say it. You're not allowed to. You're violating HIPAA laws. You're violating the ADA if you do. You should also immediately clean and temporarily close any areas that were used by the employee. You also need to be prepared. What do you do with the employees who were in contact with the person who got sick? So you need a protocol for the asymptomatic workers who might have been exposed. Really have two options here. First one, employee stays home, self-quarantines, works remotely if they can for 14 days. If they don't have any symptoms, they come back. Now, if it's an employee who has to be in the workplace, you can allow them in there, but you're going to need to screen them if you're not already. Obviously, they should wear a face covering at all times, not just when they're in contact with other people for the 14 days. And you probably want to have someone coming in there cleaning their areas more frequently than you otherwise would. Obviously, if possible, a simpler business, just have them work from home for 14 days. But that's not always possible depending on the nature of the business. So finally, you got to make sure your leave policies and posters are all up to date. And there's a bunch that potentially impacted. I just have the ones for New York and New Jersey in here. But the Families First Coronavirus Response Act was newly enacted. It does sunset at the end of this year, which means it's no longer effective, but it does provide emergency leave, sick leave, and family leave for businesses. Plus all businesses, 500 or less employees. So a lot of businesses who are not subject to the FMLA are now going to be subject to this. I do not recommend putting this in your handbook, but there are posters and you are required to post them. So they should go up. But since it sunsets, I don't think it makes sense to update handbooks to include it in there. You need to know the FMLA may be triggered if you have 50 or more employees. New York City has a very expansive paid sick leave law, as does New Jersey. Employees who are unable to work may be entitled to family leave insurance in New York or New Jersey, could also qualify for disability under New Jersey law. And again, as I mentioned, time off from work, even without pay, may be a reasonable accommodation you have to require. So you have to protect someone's job, let them be off from work either while they're sick, if they don't have sick leave, or they're not eligible for it, or if they're a high-risk individual, or someone with anxiety who this is exacerbated. Their fear exacerbates their medical condition. That would be an exception to the normally fear of COVID-19 doesn't require an accommodation. So that's all it for me. I kind of ran through it pretty fast, I know. If you have any questions, if you haven't already, put them in the chat box and we'll get them at the end. And now I will turn it back over to Chris.
Okay, thank you, Mike. So again, please enter those questions into the chat, and then we'll have a Q&A session at the end, and we'll go through everything in detail. Okay, so what I want to talk about is corporate retirement planning. Okay, whether we have a plan in place today, or we're thinking about it, whether we have employees or we're operating on our own, or maybe with a spouse, and just some ways that we can have flexibility around that, and maybe some strategies, particularly for 2020. So going through, the first thing I want to just chat about is ways that we can access funds, distribution options. And there's been a lot of headlines around this and really a lot of confusion based on the terminology. And so we did a webinar on this, I would say about 3 to 4 weeks ago, that goes into further depth. And we can certainly chat about it here. I can also send you that link if you'd like to learn a little bit more, but I want to cover it kind of on a high level. And in essence, what people are saying is, we have now this coronavirus-related distribution option in 2020. A lot of people keep referring to it as a hardship distribution. They are not the same thing. They're two different categories. So just briefly, under the Secure Act, which was legislation that was passed in December of 2019, you could take a hardship distribution. That means that if I'm an employee of a business or the owner of a business, or I have my own private 401k plan, let's say, I can access my account by having a reason. And that could be certain medical expenses, education, funeral, primary residence, and disaster event areas. Okay, so that is a hardship distribution. I can then prove that, I show documentation, and I can take funds. I'm going to chat a little bit more about the implications of that. But what's specific to 2020 is that now, as part of the CARES Act, we have these coronavirus-related distributions. And so what is the difference? What we can do here is actually withdraw $100,000 from a 401k, from an IRA, from a corporate plan, and it's in aggregate. So if I take $50,000 from a 401k and $50,000 from a traditional IRA, that's the maximum. It's not per account, it's in aggregate. So I can receive $100,000 out of my account if I need it. Now, a couple things that are interesting is, how do I qualify to get access to those funds, or my own funds really? And there's two ways. One is medical impact, and so that's you or a spouse or someone who's living in your household being diagnosed with COVID-19. And the other, which is more broad, is adverse financial consequences. So that could be as broad as, well, my daycare service is closed, and so I or my spouse need to stay home to look after the kids. Something as large as that, or operating my own business. If my hours have gone down, that qualifies me as well. So they open it up to really provide access. That's the whole thought process behind this. And so when I take out, let's just say in this example, the maximum, the $100,000, what's unique here is that normally, if I am under the age of 59 and a half and I take a distribution out of a 401k or IRA, I have to pay a 10% penalty, typically. In this case, that has been waived. So if I take that CRD, there's no 10% penalty on the distribution. The other aspect, which is very interesting, is if I do take this withdrawal, I do have to pay tax, right? It's the same concept as a hardship withdrawal. In that case, I do have to pay a penalty from under 59 and a half, and I have to pay tax. Now, for the CRD, what they've done is you can elect to either pay the tax in the first year, or you can spread it out over a 3-year time frame. Okay, and so you pay first, second, and third. Now, the other part to this is, hypothetically, let's say I'm thinking about that as a loan. And so I take the $100,000 out, I'm using it for my business or for my personal expenses, combination of the two. And then my objective is to return those funds. If I return them before the end of the 3-year period, it is deemed a rollover and there is no tax due on that withdrawal. Okay, so in that way, it's similar to a loan. I'm taking those funds out, I'm returning them, there's no tax impact. The impact, however, is that for that period of time, in this example, the full 3 years, I've had $100,000 that's no longer being invested. Okay, and so there's a time cost to that as well. So it's very flexible. The funds can be returned to any retirement account. They don't necessarily have to be the account where you took the funds from. So again, adding to the flexibility, that's ultimately the objective here. So just wanted to provide some clarity on that and the differentiation between what is a hardship distribution and coronavirus related. If you have a 401k that's in place presently, you need to review the document, or whomever you're working with, we need to review the document to determine that you allow the ability for distributions from your plan, okay? If not, that's a pretty easy change that can be done by the record keeper or the actuary, and we can get that in place and allow for that to occur. The other aspect is, I'm an employer and someone wants to take this distribution, am I liable, or do I have to do more further detail and research to determine, is this person really qualified to take a CRD? And it falls to, they self-certify. So whether me as the business owner, if I want to take the funds out, then I can just provide a letter to the record keeper or to the custodian. If I have an employee, then they can provide me a letter. That's what I would prefer, to have a letter in hand that I can file away where they have said that they qualify and that they sign off on that. And now that pushes the responsibility upon them to make sure that they actually do in fact qualify. So that's one aspect here on distributions. The other is the loan provisions. So this is more regarding corporate retirement plans. And what I mean by that is 401ks, 403bs, plans that we have administered in that kind of capacity. And so the rule previously, right, through 2019 was that if I'm taking a loan, if my plan allows for it, it has to be in the plan document, then I can take a loan that is 50% of the vested balance up to $50,000. Okay, so if I have $100,000 in a 401k, I can take $50,000. If I have $1 million, I can take $50,000. If I have, $10,000 in there, I can take $5,000. So it's one of those options on that. What's changed is that has been doubled. So now I can take 100% of my vested balance up to $100,000. So in essence, all of that has been doubled, and it's a way for us to access more capital if we need it. Now, this has to get repaid, okay? And so there's two things to think about as a business owner. If I'm taking the loan myself, I typically have a 5-year term to repay those funds, and I at least have to pay them on a quarterly basis back into the account. The other part that's interesting here is that when I take a loan, it's not reported, so it doesn't affect my credit, which is different than other ways of accessing capital. So it's non-taxable, and it doesn't affect my credit score, and I can get access to those funds. And then, like I said earlier, we have to pay it back at least on a 5-year amortized schedule on a quarterly basis at a minimum. Now, the other thing is that those payments have been delayed. So they've been delayed about a year until we have to actually start making them back into the account. When those payments are being made back into your 401k or your corporate account, they are made with after-tax dollars. So those are two things important to keep in mind, right? Again, same scenario. If I'm taking funds out, I'm out of the market for that period of time, which could be 5 years, and there's an opportunity cost there. The other aspect is I've taken it out pre-tax, I'm returning it after tax. Okay, I'm bringing it basically through my business account or through my personal accounts that are all after-tax dollars. So keep that in mind, but in essence, just continuing to build on this factor of having flexibility for 2020, okay? There's been no further guidance as if they're going to carry this into 2021. It looks like both of these options are going to end at the end of December of this year. So two things to just keep in mind, and I just want to go into strategy here. So I want to talk about strategy if I have employees, and then another version if I do not have employees, right? Or I'm working with a spouse, let's say. So in this scenario, I have employees. The whole point here, what I want to kind of talk through is that there's an incredible amount of flexibility. So if you have a 401k plan that is in existence today, okay, we break out these categories where the first example is I have these owners, right? It's an owner and a spouse. They have some staff, they have employees, and so we can see their annual salary. The owners, they want to maximize their contributions in this case. So in this aspect, they're making these contributions. The flexibility comes in if a participant wants to make a contribution to a 401k, that's their prerogative, right? That's their funds that they're deferring into the account that doesn't affect business cash flow. For profit sharing, I can either allow that to happen or I do not have to make a profit sharing contribution for 2020. I can decide that up until tax filing of the following year. So there's a lot of flexibility in terms of timing and whether I have to make a contribution. I could simply have zero for profit sharing in 2020 if I'd like, or there's ways to do a calculation to maximize what I receive as the owner, okay? Because in essence, the reason why I want to have these plans is certainly to take care of my employees and give them the opportunity to save and build a retirement, but also to help defer tax, right? We can face a pretty material tax bill every year. And this is a good way to mitigate. So profit sharing, very flexible. Cash balance plan. So we can talk further about this. The cash balance plan is another feature. It's a defined benefit plan that can basically be bolted on. So 401k is our foundation. There's a lot of different tools and resources we have available, profit sharing being one, cash balance being another. And so in the cash balance plan, again, incredible amount of flexibility here where there's certain scenarios where you can freeze the plan and not make a contribution for 2020, or you can make a very small contribution for the year. There's really a multitude of ways to structure this because what's happening is it's not a year by year benefit. We're doing a calculation looking into the future. Okay, so when we're projecting out into the future, there's flexibility around what factors we're using to determine the future value. So I can talk more about that, but in essence, what I want to show here is that if you have this plan in place today, incredible amount of flexibility in terms of contributions. This owner and spouse wanted to try to maximize their contributions while giving some benefit to the employees, but keeping it within reason for business cash flow. And so in this example, if we just go to the total contribution section, the owner and the spouse were able to deposit $430,000 into their own personal retirement accounts. Their cost, if you want to call it that, or the funds that they had to give to the employees to make this work, was $13,825. So in essence, 97% of the dollars that were being contributed went to ownership and the remaining to the participants. In essence, they were able to defer $430,000. They received about $175,000 in tax savings in that year. And also what we give to the employees is tax deductible as well. So that's why there's a tax savings on that aspect too. So really important, there's an incredible amount of flexibility with employees. I'm going to talk about if I don't have a plan and I'm thinking about possibly setting one up this year or next year, there's some factors here to consider. So we talked about flexibility. Tax credits have changed as part of the Secure Act, and they're very material. So there is a startup tax credit. If I do not have a plan in place and it's something that I've thought about and I'm pushing it off, I may not want to, because in 2020, even if I'm not inclined to make a contribution, I can get a startup tax credit ranging between $500 to $5,000 per year for 3 years, depending on how many employees I have and a couple factors. There's also another credit that's been created where, let's say I do have a plan in place already and everybody's already participating. I have a law firm, I have 5 employees, they're already in the 401k. I could actually add this auto enrollment credit and get another $500 a year as a tax credit for 3 years. If I take these combined, I can in essence run a plan for basically no cost for the first 3 years. So what I was saying earlier is even if I'm not inclined to make a contribution for 2020, I may want to set it up because then I'm going to use the credits to really offset my cost. And in 2021, if the second half of the year is materially improved, I still have until tax filing to say, you know what, I do want to make a contribution for 2020, and I have the ability to do that. Reducing taxes and increasing retirement funding, right, as we showed before, incredible amount of ability to reduce our tax burden or our tax obligation while having flexibility and increasing our own personal retirement assets. And if we need to take funds from them, we discussed some distribution options on there as well. So briefly, I just want to talk about if I do not have employees. I'm going to go through this briefly. We can talk about it in further detail, and then I'm going to turn it over to Darren. But here, if I don't have employees, normally what I see is that I've been advised to set up a SEP IRA, okay? And that's okay. But if I'm operating as like an LLC, I may want to have a solo 401k instead. I can take those retirement accounts, SEP IRA, traditional IRA, rollover, I can consolidate them to a solo 401k. There is no cost to establish. And what happens here is now for my contributions as a Schedule C, an LLC to that capacity or sole proprietorship, I'm getting the tax deduction federally and in New Jersey as well. We can always add on a defined benefit plan if that makes sense for us. And the other really attractive part is the government views us, right, if I have a solo 401k, as having a corporate account, separate than personal. So that gives me the ability to do what's called a backdoor Roth contribution every year and get funds into a Roth IRA, even if I make over the income cap, which is about $193,000. So in essence, I can make a contribution, okay? I can get tax benefit federally and in New Jersey. I can still have the ability to contribute to a Roth. And if my spouse is participating in the business, which may be a strategy to start, I can also have them set up with a solo 401k and a Roth. So incredible amount of flexibility here, and it could potentially be a very material amount of tax that gets deferred out into the future. And so in this example, if this person took those options, they saved about $75,000 in tax, and they were able to defer, almost $200,000 to their own retirement account each year. So very attractive. And again, flexibility is the key. So we don't have to make any contribution if we don't want to, but we certainly have the ability to do so. And we can always chat about this in further detail. So please feel free to enter those questions into the chat box, and we'll talk about them at the end. And I'm going to turn it over to Darren on PPP.
Thanks, Chris. Hello, everybody. Hi. So I'm going to talk about the part of the Coronavirus Aid, Relief, and Economic Security Act, called the CARES Act. I'm going to talk about the Paycheck Protection Program, which is, we call it the PPP. And next slide. You do the next slide, Chris. Okay, great. Thank you. So as part of the CARES Act, like I said, that was signed into law on March 27, 2020, the Paycheck Protection Program is a form of coronavirus relief-related provisions to business owners. Pursuant to the CARES Act, the SBA received additional funding and authority to modify the existing loan programs and established a new loan program to assist small businesses nationwide that were adversely affected by the COVID-19 emergency. Specifically, Section 1102 of the Act temporarily permits the SBA to guarantee 100% of Section 7A loans under the new PPP program. These loans can be fully forgiven if certain employee headcount and wage payment guidelines are met, as well as utilizing the money for specific purposes and having sufficient documentation to prove that you use the money for specific purposes. Okay, next slide. Who's eligible? Well, small businesses with 500 or fewer employees, including nonprofits, veterans organizations, self-employed individuals, sole proprietorships, and independent contractors are eligible. Also, businesses, some types of businesses with more than 500 employees are eligible in certain industries, such as the restaurant industry, where they have less than 500 employees at a particular franchise location. So since initial enactment, the PPP has gone through numerous changes. Just to date, The SBA has issued 19 interim final rules and 48 pieces of guidance in the form of frequently asked questions. So a lot of detail has really been put into the law, and there's been a lot of guidance that people have to kind of keep up with and follow. So it's very complicated, and it's time consuming to figure out, you know, what the PPP says and how you can use it. Also, most recently, the PPP Act, the original PPP loan program that was passed in March, was amended by the Paycheck Protection Program Flexibility Act of 2020, which was enacted just a couple weeks ago on June 5th. Now, however, the original deadline to file, get your PPP application in is still June 30th. That hasn't changed under the Flexibility Act and remains in effect. So if you want to apply for a loan, you just have a few more days to apply for a loan. Okay, most people who have needed a loan have applied for a loan. So we're at the point where we have to get our loans forgiven. So what is forgivable? So there are four broad categories of costs that are forgivable. They are payroll costs, rent, utilities, and interest. Now, payroll costs, and there's been a lot of complications around this part of it. It includes gross salaries and wages of employees up to $100,000 cap per year, meaning if you elect an 8-week period, and we'll get to election of 8-week, 24-week period later, but if you need to spend your loan money over an 8-week period, that limit would be $15,385. If it's for the 24-week period, it'd be $46,154. Payroll costs also includes employer-paid health insurance, employer-paid 401k matching, employer-paid state and local taxes. It doesn't include the employer's portion of payroll tax expenses, such as Social Security, Medicare. Also, a special note, owner's compensation replacement. This is for your sole proprietor, Schedule C type of filer. It's based on your 2019 net profit, and the maximum amount would be for 8 weeks, $15,385, or for 24 weeks, $20,833. Also, just as a special note, employee benefits paid for owners are also not one of the things that are not covered under payroll costs. Next category, rent. Under a leasing agreement enforced before February 15, 2020, which is before the pandemic, and it refers to leases of real and personal property such as office space and copiers, other types of machinery that you might have a lease payment for. Utilities, gas, electric, water, transportation, telephone, internet services, which began before February 15, 2020. Interest on debt obligations of the company that were incurred before February 15th, 2020. It doesn't include prepayments of interest or payments of the principal amounts. These loans typically have to be secured by a mortgage lien, working capital lines of credit, loans that are secured by a UCC-1 financing statement. So basically, it just includes secured debt, not any unsecured debt. Okay, next slide. Okay, so a PPP loan is forgivable to the extent that the loan proceeds are spent on the four categories within your covered period, and the employer maintains the employee headcount at pre-COVID-19 levels and maintains employee salaries at pre-COVID-19 levels, and incurs or pays these expenses during the covered period, which is now a 24-week period immediately after the receipt of the loans. Excuse me. When the law, when the law first came out, borrowers who received their loans prior to June 5th, 2020 can elect an 8-week period. So if you got your loan before June 5th, 2020, you had an 8-week period from the date you got your loan to spend all the money that was given to you. However, there was the Flexibility Act that I talked about before says that that period cannot be extended to 24-week period. So you have a longer period of time to spend all the money that was given to you, and it would increase, it likely increases your eligibility for forgiveness. So as I said here, amounts spent outside the 24-week period or 8-week period if elected, or outside one of the 4 permitted categories I spoke to about before, are not forgivable and they need to be repaid as a loan. Now, under the Flexibility Act, the repayment term is now 5 years for loans made after June 5th, 2020. If you got your loan prior to June 5th, 2020, the term is 2 years, but you can also enter into negotiations with the lender to extend that period. There's nothing in the law that says you can't do it, so you can go back to your lender and see if you can get a longer period to repay your loan. Okay, next. Once your business has determined the payments are eligible forgiveness, so that's your maximum potential forgivable amount, you'll need to complete additional calculations based upon your payroll to determine if the amount is ultimately forgivable. So I guess what I'm saying here is that you have a maximum loan forgiveness, but that maximum loan forgiveness can be chipped away at these calculations, one or both of these calculations. So first is the headcount analysis. So if your business reduces its number of full-time employees during the covered period, then the forgiveness amount is reduced by a ratio. The ratio is, it compares the amount of people you had before the pandemic and the amount of people that you had during the pandemic, and that's a ratio, numerator, denominator, and you kind of take that proportion and apply it to your loan proceeds, and it determines how much of your loan is ultimately unforgiven. And then there's the second part of that is the wage analysis, where the CARES Act, it seeks to ensure that borrowers were hiring back employees at a wage rate that was similar to pre-COVID-19 levels. So they introduced this kind of lever that penalizes companies who reduce wages per employee by more than 25% compared to the first quarter of 2020. Now, in this headcount analysis, wage analysis, this is where most of the questions come in. Both of these calculations are extremely complex. They require several data points that must be compiled by the borrower in order to meet and navigate the PPP's loan forgiveness calculations, safe harbors, exemptions. So, like I said, this is where most of the questions do come up, and if this is where we kind of are able to assist clients in maximizing the loan forgiveness amounts. Okay, now overall, one of the provisions of the new Flexibility Act was this 60-40 rule. It used to be a 75-25 rule, but through this new legislation, the Flexibility Act, the dollar amount for which forgiveness is requested includes payroll costs equal to 60% of the forgiveness amount. Okay, so, and it also says here that there's no cliff exists. So if you go below the 60%, you still can have part of your loan forgiven. Now, the best way to show this is with an example, right? So let's just take a simple example. So say you have a loan amount of $120,000, right? And you spend $60,000 is spent on your payroll, right? 60 is spent on rent. So 50% was spent on payroll. So you think, okay, I didn't meet the 60%, so none of my loan is forgiven. No, it's not a cliff. It's it's proportional. So in this example, let's assume no wage or headcount, no headcount or wage reductions are present. So the maximum loan forgiveness would be $100,000. So this is because $100,000 is the point where 60% of the loan proceeds, right, is spent on payroll. So the remaining 20% is a loan that has to be repaid. So that's in a simple example, that's really how the 60%, 40% rule works. So, okay, you can go to the next slide. Okay, so with passage of the Paycheck Protection Program Flexibility Act on June 5th, there came new applications. Before the Paycheck Flexibility Act of 2020. It was a very long application. It was like 11 pages, a single space type. It was very, very long, convoluted. So we had to study that and kind of digest it. But we're glad we did that because we kind of know how the forgiveness program better works. But they also came out with these new applications. The one notable thing here is the payment form 3508EZ, which is a streamlined form, and only certain borrowers can use it. You have to meet one of three requirements to use this form. So you can use the EZ form, which is a lot easier to complete, and it doesn't have anything related to this head count and wage reduction formulas. So you need to one of these requirements. You need the borrower is a self-employed individual, independent contractor, or sole proprietor who had no employees at the time of the PPP loan application, or the borrower did not reduce salaries of any employee earning less than $100,000 annually by more than 25% when compared to pre-COVID-19 period, which is the Q1 of 2020. And they also did not reduce the number of employees on average and hours paid between January 1st, 2020 and the end of your covered period. Or the borrower did not reduce salaries of any employees earning less than $100,000 annualized for more than 25% when compared to the covered period, and the borrower was unable to operate during the covered period at the same activity as before February 15th, 2020. So you have to fit into one of those specific categories in order to use this more streamlined, easier to figure out loan application form. So that's kind of the latest development on the PPP and loan forgiveness. So is there a next slide? Did I have a next slide? Oh, no, that was it. Okay.
So I know we covered a lot of ground, and Mike and Darren, thank you very much for sharing your background and your information with everybody. The chat's open. There's been some questions that have been coming through, so I've kind of organized them a bit so there's some continuity, but please feel free to send in a question if you have one. And so just going through PPP, Darren, we'll just start there. How about, there's a question coming through on EIDL and how that is being treated.
Right. So EIDL, that's a separate program, right? It's called the Economic Injury Disaster Loan. So that was an existing program that was created, of course, before the PPP. And those loans are non-forgivable. But however, when the pandemic happened, there was the SBA was offering through the EIDL up to $10,000 grant for businesses that need it. At first it was a $10,000 grant, then they specified it's $1,000 per employee. So this would be a grant given to you. You wouldn't have to repay it back. However, it would chip away at the amount of loan that can be forgiven under the PPP plan. So if, say, you got a $10,000 EIDL grant and you had a $100,000 PPP loan that could be forgiven, you'd have to decrease your forgiven PPP loan by the $10,000. So you net it against each other. So you would, that EIDL portion would eat away at your loan forgiveness under the PPP. So. Okay.
And another question that's here is on when to apply for forgiveness. So the question is, if I receive the loan prior to June, then when do I apply for forgiveness?
Well, you would have to apply within 10 months of the end of your covered period. So it gives you a pretty good amount of time to apply. Now, we've also seen situations where we have, everything's been, we've extended it to the 24-week period. Remember, the 8-week period or the 24-week period is elective. So if you elect the 24-week period and you spend all your loan proceeds before the 24-week period and you want to get that loan application in, there is going to be further guidance coming from the SBA whether or not borrowers want to apply forgiveness before the end of their covered period. Say you elect the 24-week covered period, and you've spent all your loan money, you don't want to wait till the end of the 24 weeks, there is a possibility that you'd be able to apply early, but we're still waiting some guidance on that, what the process would be. But it's a good idea that even if that does happen, to get all your documentation in place, start looking at the application, start doing your calculations, and a lot of clients are doing that here. So.
Perfect. Thank you. Switching over to Mike, a couple of questions for you, Mike, that have come through. What's okay for medical checks? Actually in office or sign a document?
You can do either. Some businesses are having employees sign, a Jot form or a Microsoft Forms or a Google form before stating whether, confirming that they don't have any of the symptoms, or that they've checked their temperature. Obviously, if you're doing a temperature check yourself, you're going to have to do that one in office. I personally prefer having the employees sign off before they come in, because you don't want to have someone come in with the symptoms and have to send them home then. If they had the symptoms, they shouldn't have been coming in the first place. But there's not one required over the other. So either is an option. You got to see what works best for your business. Obviously, small business is probably easier when they come in. You could do it if they come in. If you have a workforce of hundreds of people, you don't want them standing all together, in a line 6 feet apart, filling out a form. So that'd be easier to have them do remotely before they report it.
Okay, great. The other that I'm seeing is workplace controls. Is that up to the business owner or is there law? So I'm assuming that's regarding what you mentioned about, shutting down the cafeteria area. Is that at the direction of the business owner?
Well, it varies. Everybody said all the guidance, and even New York, which has some of the strictest requirements, requires you to consider it and basically shut it down. Unless there's a legitimate business reason you need that space open, it should be shut down. It's consistent with what the CDC says. That's what New York is requiring. New Jersey's laws have not been as specific, but they all cover the same things. You don't want people congregating in areas together where they're not going to be able to stay apart.
Mm-hmm. And then last one here that I'm seeing is, and then we can always chalk offline if you have additional questions that we didn't get to, but last one here is, can I open my business? And I'm assuming that's following, with all the different sources that are out there of news. How do you determine really if you qualify, or maybe you've always qualified and you didn't have to be shut down in the first place?
Yeah, we were talking about this offline beforehand. There's been a lot of confusing information. You need to check the laws, which are the executive orders. When this first started, particularly in New Jersey, at the press conferences, the sound bites were all that the governor closed all non-essential businesses. And that's not what any of his executive orders actually did. He closed specific businesses like hair salons, tattoo parlors. At some point, he closed non-essential construction, but the primary order was he closed non-essential retail businesses to the public. So those retail businesses could have stayed open the whole time and taken phone orders. Could have taken curbside delivery orders. He later came out with specific guidelines for how curbside delivery was supposed to be accomplished, but that would not have been being open to the public. Professional services firms were never closed, but all businesses were told minimize in-person people to the extent possible, permit teleworking to the extent possible. But yeah, you need to look at the orders, not what the news is reporting and not what's being said at the press conferences, because that's an abbreviated version of what has actually happened and what the law is required. So check the executive orders, consult with your lawyers. That's really the only way to know exactly, what can be open, whether you were really closed, to what extent you can open.
Perfect. And then one question on corporate retirement, time frame to set up plans in 2020. There's increased flexibility. So you have until really through the end of this year. It used to be that by 12/31, I had to get everything established to count for the year. The Secure Act opened that up a little bit, so there's more flexibility in terms of timing. But nonetheless, we don't want to miss that window if that is something that's being considered. and it's certainly worth a conversation before you make that decision or that call. So thank you for joining us again, Mike, Darren. Thank you for your insight. And
My pleasure.
we'll have a copy of this. If you need it or would like a copy, please feel free to email me directly and our team will get that out to you. And again, any questions that you have, please feel free to reach out and we can direct you to either Mike or Darren or myself, depending on what you need. So have a great rest of the day, and we appreciate you joining, and we'll see you soon.
Thank you,
Thanks,
everybody.
everybody.
Thank you, everyone.
Thanks.